Welcome to Employment Law This Week. I'm George Whipple. Every employer knows it's important to protect trade secrets, but employers must first establish ownership of those trade secrets, starting at the beginning of an employee relationship. That's the subject of this week's Spilling Secrets, Epstein Becker Green's podcast series about trade secrets and non-compete law. Standard employment agreements require employees to assign ownership of intellectual property to their employer. But recent legislation in several states has introduced new restrictions on those agreements. New York is the latest state to pass a new law in this area. SB 5640 makes unenforceable any provision requiring an employee to assign to an employer the invention the employee develops on their own time. In order for this law to apply, the invention must be developed without the employer's equipment, supplies, facilities, or trade secret information. Epstein Becker Green's Adelee Traylor tells us about similar laws across the country.
10 other states currently regulate employee assignments of IP. Those states are California, Illinois, Minnesota, New Jersey, Delaware, Kansas, Nevada, North Carolina, Utah, and Washington State. All of these states' laws, with the exception of Nevada, favor employee ownership and mobility, but their scopes vary significantly. One area of differentiation among these laws is the type of employee inventions the laws exempt from the employee favorable carve-out. For example, both the New York law and Minnesota law exempt certain inventions that relate to an employer's business.
Epstein Becker Green's Jim Flynn discusses potential issues employers may run into with their agreements. This includes one key idea that often gets overlooked: tense matters.
Even statutes like Adelee was discussing and common parlance has us saying you're going to assign the rights to things you create. But if you write the agreement in that fashion, there's case law that's come out over the years that says agreeing to assign is just agreeing to agree and not really enforceable. And so what you have to make sure is at the inception of someone's employment relationship, you're writing it in such a way that they're presently assigning and using the present tense. I hereby assign the rights to anything that I will create or that I have created within the scope of my jobs and duties.
Inventors are often prolific at inventing, which means these employees likely have prior inventions before joining the business. Epstein Becker Green's Hemant Gupta tells us employers can address this issue from the start of the relationship.
A good way to start is to have the new employee list all of the inventions that they own as part of the employment agreement. And those employment agreements should also clearly define and agree on the ownership of any existing inventions. So you want to ensure that the employment contracts include provisions that grant the employer licenses to those inventions owned by the employee so that you don't later get accused of infringement for using or incorporating technology that the employee had owned.
The team continues the discussion from there, covering the limits of the copyright statute, inventive contributions versus general knowledge, and how Formula 409 got its name. A very interesting story and highly relevant. Listen to the podcast to find out how. Subscribe to the Employment Law This Week feed wherever you get your podcasts to hear the full audio episode and to catch all future editions of the Spilling Secrets series. Thank you very much for watching, and we'll see you next time.